Assalamu alaikum, everyone. Good morning, and thank you for joining us today. And welcome to the first session of Al-Nukhba Program. We are truly pleased to have you here with us today. An initiative aimed in supporting local Qatari companies and their listing journey in the capital markets. Today's topic is corporate governance, and we are fortunate to be joined by two experienced speakers from Clyde Co, one of the most respected legal firms in the region. First, I'd like to introduce Mr. Elias Matni, a partner at Clyde Co. Elias has been based in Qatar since 2008. He advised local institutions, government bodies, and private sector clients on matters including mergers and acquisitions, joint ventures, capital markets, and corporate governance. Joining him is Ms. Maha Lawson, a legal director at Clyde Co. Maha brings many expertise in both Qatari and international clients on a wide range of corporate issues. Her area of expertise include mergers and acquisition, debt capital markets, corporate governance, and compliance. Before we begin, just a quick reminder on today's session that any questions and answers will be kept to the end. You can either raise your hand and I can unmute you, or you can directly type it in the chat box. With that, Elias, Maha, the floor is all yours.
Thank you, Sulaiman. Assalamu alaikum, everyone. It's a pleasure to be part of this program. Also, it's a pleasure to be spending the time in the next hour or so with all of yourselves, and thank you for dedicating some of your time today. I know you're probably very busy post-Eid vacation. We're going to try to make the use of this time to make sure you receive as much as info as possible on the topic itself. I'm going to go immediately into a quick introduction of Clyde Co, so everyone is aware who we are and what we have been doing in Qatar. Clyde Co as an organization, it's formed of 500 plus partners and 5,000 employees. It's a global international law firm. Main office is in the UK with 65 offices across the world. We in the region, we are present in definitely Qatar for many years now. We're one of the first international law firms that were set up in the Qatar Financial Center in 2007. We are also established in Saudi Arabia and Jeddah and Riyadh. And we have a long-standing presence in the UAE, in Dubai and Abu Dhabi. But as part of our family in the Middle East, we extend also our offices to Africa. So as part of the Middle East presence, we are joined with Africa as well. So we have Egypt, we have South Africa, Tanzania, Kenya, and Ghana, and we service other offices. This is, of course, other than our European presence, our North and Latin and the Americas, and as well as Asia. In the region, in terms of our focus areas, we focus on health, education, retail, infrastructure and projects, and energy. So our clientele, vary within those areas. We have been present as individuals in the office for many years in Qatar. Most of us have been serving here for over 15 years or have lived most of our lives in Qatar. We have skilled lawyers from common law jurisdictions and civil law jurisdictions, so we can serve clients in both those areas of law. As a Doha office, we have main three practices, mainly corporate commercial, which we are part of it. I'm leading the practice. Myself, Maha is a legal director, and we have other colleagues. We're a total of 7 people on the ground. and the corporate practice. We have a large construction and projects and dispute resolution practice as well, led by a partner of mine, Jonathan Parker, who's been also practicing for several years. And he have a team on the ground who's also busy, I'm sure, with disputes in the sector itself, post the World Cup and the issues that has been facing many of the construction clients. And we are also fortunate to have a standalone employment and immigration team led by my colleague Emma Hayam. Emma has been in Qatar for 20 years, and she's been advising on employment and immigration matters. Our regional presence and certainly in the GCC is very extensive. We are very heavily invested in the region. We are almost 70 partners across the GCC, around 300 lawyers spread between the three GCC countries that we have offices in. Historically, we're very close to family and regional conglomerates, certainly in the UAE, as well as Qatar and Saudi Arabia. So we like to help family businesses advance. We help them restructure and reach the goals that they achieve as businessmen, and also successions, help them into succession planning, and hopefully taking the scale up and going into the market. So this is who we are as an office. Just briefly, not to show off or show how good we are. It's not the case. Some of the transactions that we have worked on are successful, big in nature, but they probably also non-successful, but we have worked on them. And it's just to share some of our main credentials. Of course, we have much more than this. We're fortunate to have been a part of the team who's worked on one of the first takeovers that happened in 2010 in Qatar. I remember we had to draft takeover regulations overnight to make the deal take place between Barwa Real Estate and Al-Iqariya at that time. We advised also on one of the first mergers in the banking sector between IBQ and Barwa. It was a one-of-a-kind transaction merging a conventional bank into a Sharia-compliant bank, which led to the establishment of Dukhan Bank after a year or so. I was fortunate to be part of the team also that after a couple of years advised on the direct listing of Dukhan Bank, from structuring to the bearing at the Qatar Stock Exchange. We've also been advising on IPOs, readiness exercise, and restructuring of organizations. Many of them probably haven't made the market yet, but we're hoping that many will reach the market soon. I was part of the team that advised on the setup of Vodafone Qatar back in time when they got the second telecom license, and helped them in their IPO process, which was unique in the market at that time. And also myself and Maha have been extensively advising public listed companies on their governance reporting and advising on their disclosure reporting vis-a-vis the Qatar Financial Market Authority. This is in short who we are, what we have been doing. Of course, I should not forget that we advise on company setups, joint ventures, and review of complex contracts. I'm going to move now into our topic. Myself and Maha, we're going to split the roles today on this topic itself. Corporate governance is a bit theoretic in nature, but it also I don't want to describe it as complex, but it's a key thing that we look at as advisors, and notably listing advisors and valuators when it comes to the shape and structure of the companies that we are dealing with when we are doing an offering or a listing exercise. It's a key thing that we look at because it helps us determine whether the organization we're dealing with is well structured. It has the right infrastructure from terms of management, policies, control, risk control, reporting, and and in terms of fairness of dealing between the management and the other stakeholders. Governance itself started as a concept from my own research and studies in the 1970s in the Americas. As usual, the US do export for us troubles from time to time, as of what we're seeing in the recent days. So in the Americas in the 70s, they started to focus more on what really companies are doing internally, how they are functioning, and the concept came up. Down, a few years later, many international organizations, such as the Organization for Economic Cooperation and Development, did issue standards for governance that then became as the main principles that we deal with in the current days. Now, of course, every jurisdiction probably has adopted its own governance standards, but the principles remain the same. In Qatar specifically, the concept started to be introduced in 2014, and then in 2016, the QFMA issued the main market governance rules for the primary market itself. And then in 2019, sorry if the dates are not very accurate, but also the Ministry of Commerce and Industry issued the governance rule related to private joint stock companies. And of course, there is the governance rules dealing with the venture market, which was issued in 2014. And the Qatar Central Bank for Financial Institutions has issued relatively recent governance code in 2023. I remember when we were doing the Dukhan Bank listing, we had to adjust many of our prospectus sections because the governance code hit us in the middle of the transactions. The main principles of governance are around risk management, ethical standards, accountability, and disclosures and transparency. The QFMA, when issued the governance code for the main market, and we're going to focus on the main market, but what I would just like to highlight, the principles are very similar within the other codes, even the code that was issued by the Ministry of Commerce or the venture market or the Qatar Central Bank. The QFMA, when it issued the governance code for the main market, focused on 3 standards, which are transparency, responsibility and acknowledgement, and justice and equality. Transparency means acting in good faith, honesty and openness, integrity and disclosures. There's a fiduciary duty on the board to act in the best interest of the company, and not for any personal investments. The company as itself, when it's born, it's a legal entity. It should be dealt in separately from the assets of the founders and the personal interests, and should be managed in complete transparency. That also deals with dealing with insider trading, avoiding conflict of interest, and dealing with related parties. This all falls under the umbrella of transparency. Responsibility and acknowledgement of that responsibility, it mainly falls on the top management, but also top management in normally listed companies or public shareholding companies fall within the board of directors. Then it falls down to the senior management and all the committees that arise out of the of the management structure. This also contribute to rights, duties, and obligations of the managerial functions. The control and accountability. This includes internal control, such as putting the right committees and policies and terms of references in place, and social responsibility, which also make sure that the companies are contributing to the society, the economy, and protecting the environment. As part of this, there's also external controls, which will be detailing or speaking in a bit more detail and as we go more in depth into this presentation. External control mainly is the advisors that you engage in helping you, making sure you are managing the policies and the frameworks that you are putting in place. The external auditors play an important role in your governance reporting, and we will talk about this in more detail in a bit. Justice and equality, and I think when the regulator drafted the governance code, have really put a huge paragraph and too much words into what does it mean, justice and equality. Justice and equality means that all shareholders and stakeholders are equal. They should be equally treated. They should have access to information, no discrimination whatsoever. The protection of voting rights, protection of participating in choosing who is going to be managing the company, the board nomination process, making sure that there's transparency when it comes to dividend distribution and approving those distribution, or taking commercial views to not distribute to the best benefits of the business. Also, when determining the remuneration of the board members, should be transparent. Everybody should have visibility and participating in the decision. Most importantly, there is focus on protection of minority rights, and the code do focus on this. And this is mainly not to allow the majority to control the decision making, to allow some room for the minorities to participate in the decision. Also at board level, not to allow certain individual to have sole control, and of course to make sure there is a clear disclosure mechanics vis-a-vis the regulators. I'm going to stop at this point, and I'm going to allow Maha to start her part of the presentation, and of course we will deal with other sections a bit down.
Thank you, Elias. So I think, just as Elias was referring to the main principles of corporate governance, the thing to bear in mind is that obviously the board of directors is responsible essentially for making sure that these governance procedures and policies are in place. So they play a very important role in this. We will be looking at effectively what the duties, responsibilities and obligations of the board as well as the members are. And we'll talk a little bit about the composition of the board, the conditions for membership, the convening board meetings and also the board committees. I think with this in mind, given the various duties and responsibilities and obligations that the individuals have, there's a lot that goes into who are the right candidates and who's actually eligible or would be best placed to serve this purpose, taking into account the duties and responsibilities. And it's something that companies will need to take into account. Looking at the duties and responsibilities, as Elias mentioned, the board is responsible for all shareholders, protecting the interest of all shareholders and not just a shareholder that it might represent. It must exert the necessary care to actually manage the company in an effective and fruitful manner for the benefit of shareholders, other stakeholders, as well as contributing to the economy as a whole. Again, principles of good faith. They also need to carefully think about what powers are delegated down to senior executive management members and what authorities the board would want to maintain. There is also an obligation on the board to make sure that all members are trained, are aware of what their duties and responsibilities are. When new board members come on board, they need to take into account having an orientation program so that they are fully aware of their obligations, the do's and don'ts, if you like, so that they are able to carry out their duties effectively within the legal framework that governs them. In terms of board members themselves, they will need to make sure that they are attending meetings regularly. They do not resign from the board unless this is necessary and at the appropriate time, so that it doesn't leave the company in the lurch. They should always, as an individual, we're talking about individual members and not the board as a whole, they should be putting the interest of the company and the shareholders first and not their interests. They need to participate effectively in board meetings and give their opinion on strategic matters. It's not really useful having somebody sitting on the board who's just there silent and does not participate. At the end of the day, they are responsible for managing and running the company. They also need to participate in the general assemblies of the company as well. Every individual board member is responsible for making sure that the governance framework and policies that are in place within the company are implemented effectively, as well as making sure that these governance policies are developed on a regular basis to keep up with market changes and best industry standards. By way of an example, one thing that is sort of developing at the moment is the green framework and sort of the ESG frameworks, which is starting to infiltrate into the market as well, with the Qatar Stock Exchange having a voluntary green reporting policy, and also in the Qatar Central Bank for the financial institutions, there is an element of that. But this is something that will be developing, and it's something that board members will need to take into account to develop the policies as and when that happens, as well as there will have to also be monitoring the performance against the governance policies and standards that are in place. With that in mind, we'll have a look at the composition of the board. Again, this is a general overview. As Elias mentioned, we are talking generally about the commercial companies law as well as the corporate governance code for the main market. The composition of the board, there are certain requirements under the Qatar Central Bank governance guidelines, so this is just supposed to be an overview and does not aim to address every single scenario. So simply, the commercial companies law says that the board of a listed company needs to consist of between 5 to 11 members, a third of which must be independent. And what we mean by independent is there are certain things. For example, if somebody holds more than 1% of the shares in the company, they can't be regarded as an independent member. If they are a member of the senior executive management, or they are related to a board member or a senior executive management, or have had any direct dealings with the company in the preceding 2 years, they can't be regarded as an independent board member. In addition to that, the majority of the board members will need to be non-executive. What that means is that they're not effectively working for the company or getting a salary for what they're doing. The company may also decide to allocate a seat on the board to represent employees and another to represent minority shareholders. Generally, the term of the board is for a period not exceeding 3 years, except that on the first board, upon the conversion of a company for listing, the term of the board can be for 5 years. And normally what happens, the board of directors are elected by secret ballot, again, save for the first board following conversion for listing, which can be appointed for a period of 5 years. In companies where the government has a shareholding, they can actually appoint board members rather than take part in the elections. I think it's very important to take these criteria into account, because as we proceed and we talk a little bit about board committees, etc., we will see that determining the composition of the board and the number of members, bearing in mind the requirement for a third independence and the majority of non-executives, plays a very important role when determining the size of the board. We won't go into this in much detail, but in terms of conditions for board membership, they have to be over 21 years, they have to have full capacity, no previous convictions, not declared bankrupt, and except for independent members, they should have hold the minimum number of shares determined in the Articles of Association as guarantee shares for their membership. A couple of other things to also highlight, and obviously Qatar being a very small market, this sometimes becomes a little bit tricky, is that no individual person can be the chairman or the vice chairman of more than 2 companies in Qatar. No person can be a director in more than 3 companies. You can't be a managing director in more than 1 company. And no person can be a board member of 2 companies carrying out similar activities. And also to bear in mind, a chairman of the board cannot hold an executive position in a company. So he cannot be the CEO, he cannot be the managing director of a listed company. In terms of board meetings, there's a minimum number that has to be held, and there shouldn't be more than 3 months that pass without a board meeting being held. Usually the chairman will call for a meeting to be held, or if 2 members request it, then it has to be called. At least half of the members will need to be present for the meeting to be quorate, and the chairman or the vice chairman will also need to be in attendance in line with the QFMA Corporate Governance Code. The decisions are normally passed by a majority, and the chairman will usually have a casting vote. The thing to bear in mind is that sometimes you don't need to hold a meeting to pass a resolution at the board level. This can be done by circulation in cases of emergency, provided it's signed by all board members and it needs to be ratified at the next board meeting. So the board has a lot of responsibilities and duties, so it can delegate some of these to board committees. Now, the board committees, upon the board being elected, they need to appoint a minimum of 2 committees, and we will explore the role of each committee and its duties. We've got 3 committees here. We've got the Nomination Committee, the Remuneration Committee, and the Audit Committee, and each have a separate role. However, the QFMA does allow for the Nomination and the Remuneration Committee to be combined. So you need to have a minimum of 2 committees in place as a listed entity. The Nomination Committee, when electing or appointing members to the Nomination Committee, the board will need to take into account the duties of this committee in order to determine who is most appropriate to sit on that committee. So some of the things that they will need to look at, they will need to develop principles for the election of board members, and they need to vet candidacy applications for potential board members. They will look at senior executive management roles and nominations for candidates to fill those. They will have to have succession planning, so they have to have a particular plan in place in terms of how to fill vacant seats, whether that's on the board level or at the senior executive management level, in a prompt manner so that these positions can be filled very quickly. The nomination committee also has the obligation to have an annual performance, if you like, of the board, to specify the strengths and weaknesses and the recommendations to the board in that regard. And you see it has to be composed of 3 members. The chair has to be an independent board member, and the majority of the members have to be independent. The Remuneration Committee, as the name suggests, they're responsible for determining the remuneration to be paid to board members, and also incentives to be paid, for example, to senior executive management, as well as any share incentive schemes for employees of the company that might be in place. So these are some of the things, again, that need to be taken into account when determining who sits on these particular committees. Again, it has to be chaired by an independent member, and the majority should be independent members, just given the nature of what they do. The Audit Committee has a very important role, and as you can see, again, they have to be majority independent members, and given the duties of the Audit Committee, it can't be anybody who has previously dealt with the accounts of the company in the 2 years prior to being nominated to be on this committee. And it's the only committee where the code specifies that they must have a minimum of 6 meetings per year. And we will see that they've actually got quite a lot of duties. We're not going to go into this in any great detail, but effectively what the Audit Committee needs to do, it needs to put in place an internal control system. It's responsible for the appointment of external auditors, making sure that there is coordination between the internal control function of the company, the external auditors, the need to review the financial statements and reports, make sure information that's being passed on is accurate, information that goes to the shareholders. They need to put into place policies and systems for risk management, review these policies, have training in place. They are also responsible for monitoring related party transactions, which we will come to a little bit later. They will need to look at specific matters that the board might raise to them for investigation. Then they will need to conduct investigations into that, and they also need to provide periodic reporting to the board. And some general considerations is that the board will need to effectively appoint these committees, decide on the structure and the composition, the number of meetings, how it conducts its business, and the competencies and functions of each of these committees. And in doing so, it will need to approve and issue the terms of reference for each of these committees. Some other general considerations is that the chairman of the company cannot sit on any of these committees, so that's quite important to note. And the chair of the audit committee cannot be a member of any other committee, and a member cannot chair more than one committee. Now, with these criteria in mind, if we go back to what the Commercial Companies Law said about having 5 to 11 members, what we will note is that given the various requirements, having a small board of 5 people is really not going to be appropriate, because you're not going to be able to fill all the various seats and meet all the various requirements for board committees and what have you. So these are the sort of things that need to be taken into account when you're trying to determine the composition of your board and the membership as well. We'll pass on to Elias now to talk a little bit about reporting and audit requirements.
I mean, obviously, this is probably a topic that is of interest, and probably many companies that in the market that are not yet public would be worried about what's going to happen to us when we go public in terms of obligation to report and interact with the regulator. What I can say is that the regulator do focus on governance. do focus on the reports that come on yearly basis at the main market. There's been a lot of changes in the regulator, I would say, implementation since it issued the governance code. Of course, when the regulator issues a code and puts an obligations, it might not take into considerations all the implications on the companies. And this is normal when a new legislations come in place. So down the line, the QFMA has changed how the reports is shaped and how the reporting is made. What I can say to the audience is that this becomes a yearly exercise, simple to do once you go through it once. As you could see, if you go to the investor relations section to many of or all the public companies on the stock exchange, you will see that they publish their corporate governance report, which also is useful for the audience to have a look at. Most of the reports looks alike for a main reason because the QFMA has issued few years ago, sort of a matrix or a sample of how the report and the headings that are part of it. Again, the QFMA, I would say, 8 years ago was have taken a strategy on the reporting and was very strict. And I would say probably many of the listed companies were facing issues and troubles. And not to scare the audience, but I think it's also important to put in mind a regulator has a specific function, and its function is to make sure the quality of the companies that are on the market are giving the best image of the country and also are advancing as the international markets are advancing. Now, I think before we talk about the report itself, as you're seeing on the screen, is to say who normally does these reports, who work on it internally as in a company. In the governance report, there is an important function called the board secretary. In most of the listed companies, the board secretary plays an important role. He is the liaison between the different functions in the business. He is the eyes and ears of the board. He interacts with the senior management in terms of communication and coordination with the chairman, vice chairman, and board members. He plays a role in making sure the company is sticking to the regulation in terms of disclosures, reporting, and periodic disclosures as part of the obligations under the offering and listing rules. The board secretary should be either of legal or accounting background with a reputable degree, and then he should have served at least 3 years in a similar function. Normally, we see in companies that the legal department also takes the role of the board secretarial, but we also seen in other listed companies that it's a separate function and the governance sits under its umbrella. Who feeds into the reports. So basically, the governance department or the board secretarial department will start working on the report normally towards the end of the financial year. Mainly, I think many of our clients start thinking of it as of October, November, as part of closing the financials, and of course, it has to be part of the agenda of the annual general assembly meeting. Companies listed on the primary market has an obligation to report on yearly basis and to show the report to the regulator, and the regulator will look at it into details, will raise questions, and will make sure that it complies with its own requirements. In terms of the content of the report, the governance code and sets out the main principles that should be contained in the report. As you could see on the screen, the report has to, one, show how the company has been following and complying with the rules and regulations applicable to it. If it has been subject to any violations and sanctions, it should disclose and also disclose what were the remedial measures. It should show how the risk controls and risk management functions are advancing and functioning. It should give comfort to the market about the sustainability and the continuity of the business. It also provides a summary of how the board was functioning at meetings and compliance with minimum meeting requirements and the committee's functions and meetings. How the company is managing risk and any international market change. Certainly in these days, companies who have multinational presence are looking into how tariffs are gonna for example affect them. This is part of the stuff that the company should show to give comfort to the investors and the future investors. It also gives a summary of the performance of the board and the senior management. It also discloses in full transparency if there has been any failure in the control systems. It also makes sure that there is a disclosure of any issues that could affect the share price. For example, if the company is contemplating to grow, to do any merger, acquisition, or probably reducing size, anything that comes or can affect the share price should be disclosed. They should also disclose litigation and cases that the company is subject to. They should also disclose related party transactions, which we will discuss in more detail in a bit. Now, on the main market, and I think this is something that has also been reinforced by the QFMA and also to make sure the companies are adapting good governance procedure. The external auditor now plays a very important role in the governance reporting, and the governance code have given the auditor a mandate and function that they do as a yearly basis to make sure that the company is compliant with the governance reporting. So as part of the yearly audit that happens, all the external auditors will also do an audit on the company that also starts within probably October, November, December, and I think completes with the financial year ends. And then the auditors comes up with a report about its own view on how the company has been adapting to the governance policies and functions. Now, most importantly, if the auditors see that there is any major risks, the auditors have, from their own initiative, an obligation to immediately report the risk to the company and make sure it acknowledges it. But more importantly, their auditors and the external auditors can report this to the market itself, to the QFMA. And if there is a major risk that the auditors foresee the company is not taking action, they can immediately call for a general assembly and inform the QFMA of the reasons why they are calling for the shareholders to come and deal with a situation probably the management is not dealing with. So the auditor's report covers, assessment of internal control systems, sustainability and execution of obligations by the management, and gives comfort of the business continuity, development and appropriateness of the compliance and internal policies. It also assures that the company is compliant with its international standards when it comes to financial reporting, and there is and also they disclose that the company has been cooperative in disclosure of information. This is obviously, I would say, if you want to compare being on the main market or the venture market, it's the venture market normally allows companies a bit of oxygen to adapt to these reporting requirements. And I think it allows them a 3-year grace period to start compliance. which probably in those 3 years, the company will be ready to transition from the venture market to the main market. As many of you know, the venture market started to be much more active in the last few years. There's many companies that have selected to go into the venture market. I would say in terms of process, it's very similar exercise, but in terms of probably from a governance perspective, it's less stringent to be on the venture market, just for an adaptation period, and the regulators interact during those 3 years to make sure the companies are functioning in the right direction to make the move to the primary market. I'm going to stop here. I'm going to allow Maha to talk about very important topics as well, that are probably is a major issues that we foresee from legal perspective, which is related to related party and conflict of interest as well.
Thank you. So I think what we mentioned is that one of the main governance principles is effectively trying to manage conflict of interest as well. And one of these elements that is regulated and the QFMA Corporate Governance Code addresses, as does the Commercial Companies Law, is in relation to related party transactions. Now, in trying to understand what that actually means, we'll have a quick look at who a related party is. This is the definition from the Corporate Governance Code, which is effectively anybody who's a board member of a company or a senior executive management of the listed company or any company in its group, somebody who holds 5% of the company or any company in the group, or as a relative of any of these individuals. It will also include a legal person, i.e. another entity or company who's controlled by a member of the board of the listed company or a senior executive management or one of their relatives, or a company that's participated in a project with the company or has had a transaction with a company or a company within its group. So in terms of the definition of related party, then what does a company need to do in relation to this? One of the things that it needs to make sure is that the board has to have a clear written policy on how to regulate conflicts of interest and how to deal with related party transactions. And this is something that has to be reviewed. And as we mentioned, the audit committee also plays a role in reviewing the dealings of related parties to make sure that it's in line with relevant controls and policies that are in place. Any related party transactions that a company is a party to has to be disclosed within the annual report, as Elias referred to. And also there's an obligation on board members as well as senior executive management to disclose any interests that they have in any transactions or dealings that the company has to the board. And they will have to disclose the type of that transaction, the value of it, and who is actually benefiting from that transaction. There are certain transactions where the shareholders need to approve, any certain related party transactions and the related party policy have to be presented to the shareholders for approval. One thing to bear in mind is that board members need to recuse themselves from board meetings where a transaction that they're a related party to is being discussed, and they shouldn't take part in voting on those transactions. One of the other areas that the QFMA and obviously globally is quite important is insider trading. The QFMA legislation and regulations have been dealing with this for quite some time. However, recently in February of this year, the Code of Business Rules were issued, which deals with this matter in greater detail. So simply put, what is insider trading? First of all, who's an insider? This is somebody who has access to certain information within the company because of their position, be it board members, members of board committees, members of the senior executive management team, professional advisors, lawyers, auditors, etc., or anybody who's got a contractual relationship with the company who, due to that contractual relationship, becomes aware of information which is not available to the public. This could also include family members and employees of the company. And the information, as we said, is information that is not publicly available. So what do the regulations say about insider trading? So there's a prohibition on trading in securities based on insider information that has been obtained. This would be direct dealings as well as indirect dealings. So if an employee is aware of certain information relating to the company, they cannot go and buy securities or sell securities because they're aware that a contract which is quite lucrative is being terminated. They can't tell a member of their family or a friend that, oh, I know that this contract is being terminated, so please go and sell your shares because the shares are going to drop, because there's a clear prohibition. That information is not publicly available, and it's against the regulations to do so. Additionally, I think what's important to understand in light of this is, when is information deemed to be publicly available? This would be disclosures that have been made through the market, information that's in documents of the company where the public is permitted to see, information which can be derived from other publicly available information will also be regarded as information being available to the public, and information that has been obtained without overstepping or breaching any privacy or confidentiality obligations are deemed to be information that is available to the public. Again, we're not going to go into this in great details. I'm just conscious of time. The company needs to have clear policies in place on insider dealings. And this, again, is very important. And the only other thing that I would refer to in this context is that under the QFMA listing rules, there is a lockup period where insiders are prohibited from buying and selling securities for their own account or for the account of others in certain periods, sensitive periods, one of them being 5 working days before the board is supposed to meet to discuss the annual financial statements of the company and to approve the same. And this prohibition continues until that board meeting is held and the financials are approved. And to safeguard around this, the listing rules also prohibits the financial statements being made available to the board or to anybody in the company for a 3-day period before the board is actually supposed to meet. And also other lockup periods is 3 working days before the disclosure of quarterly and half-year financial statements in the market. Then again, trading is prohibited during that period. I think just to touch up very briefly on shareholder rights, and I think we addressed some of these at the beginning when we were talking about the main principles of corporate governance. A few things to bear in mind. Again, all shareholders are equal and have all the rights connected with their ownership of the shares as per applicable law without any discrimination. So in terms of some of the rights that shareholders are entitled to, this is access to information about the company. The articles of association of the company need to clearly stipulate how shareholders can obtain information to enable them to exercise their rights as a shareholder. And as we mentioned, the audit committee has an obligation to make sure that the information disclosed to them is accurate in order to enable them to exercise their voting rights based on correct and complete and accurate information. Shareholders also have the right to attend the General Assembly meetings, where a shareholder who holds more than 10% or more of the share capital of an entity requests for a General Assembly to be convened because there are serious grounds to do so, then the company will need to convene a General Assembly. And the threshold for this is shareholders holding 25% of the shares for the purpose of convening an extraordinary General Assembly. Also, during the annual General Assembly, shareholders have the right to request for items to be added to the agenda, and they also have the right to actively participate in the General Assembly or to nominate somebody to attend on their behalf. And as we mentioned, they've got the voting rights, whether it is at the General Assembly and also when it comes to election of board members. And finally, on the dividends, the articles will have to specify the minimum dividends payable to shareholders, and the board will need to have in place a clear dividends policy, and shareholders will need to be informed of this, and this needs to be referred to in the corporate governance report. With that, we will stop. So this was a whirlwind ride through corporate governance. And we'll open the floor to any questions.
Thank you so much, Elias and Maha. That was a very informative session. So may I remind everyone, if you have any questions, please, you have the question and answer icon, so you can post it there, or please raise your hand and I can unmute you. So I can see some questions starting to appear. So the first question, does the board secretary need to be independent?
He's an officer, so he's an employee of the company. Definitely, he should have any direct interest, but he's not a shareholder. He's not. He's an employee. He's a part of staff.
Okay, clear. What will happen if the board of directors did not meet with the minimum number as per the in a year as per the QFMA corporate governance code?
So basically, this comes as part of the yearly reporting requirements. If there is, for any reason, an emergency where the board has not been able to meet, there should be justification in the report why the board has not been able to meet. However, the QFMA will probably take actions if the board has not met on the requisite number of meetings, or if a clear justification was made, then probably there is room for discussions with the QFMA. Now, the company's law has evolved, and we should also understand that there is link between the governance and the company's law and the articles of association. There is mechanics that has been allowed in the last 10 years to hold meetings, not physically, to facilitate all these, I would say, formalities, pass resolution in writing, and then confirm these resolution in another meeting. So as long as the company is showing all these evidence, I think they're safe from any sanctions or violations.
Great, thank you. Another question we have, do related parties vote in the AGM or annual General Assembly meetings? Is this a conflict of interest, especially when it comes to strategic matters or strategic decisions?
So there are certain types of transactions where I believe it's Article 109 of the Commercial Companies Law, which requires both board members and shareholders to recuse themselves from a board meeting or a shareholder meeting when it comes to voting or in a meeting that's actually going to discuss that particular transaction that they're a related party to, then they need to recuse themselves from that meeting.
Okay. Another question, what are the qualities that will be looking for when appointing the independent directors and the board?
Sure. So for independence, it has to be people who are not related to existing board members. They have no relationship with the company. They haven't worked with the company for a period of 2 years. They don't hold shares exceeding 1% in the company. They do not control, for example, a company that holds more than 5% of the shares of the listed company. And also generally, just away from the independence, it has to be individuals who've got skills. And again, away from the independence, you shouldn't have, for example, 6 lawyers sitting on the board. You should really have a bit of variety, somebody who's got a bit of HR experience, somebody who's got a bit of finance experience, legal experience. You need to mix it up in order to allow that variety to help in decision making.
And I think most importantly, when choosing individuals, you need to choose individuals that know the business. They have experience in the nature of your business. So if you're in healthcare, you're in retail, you're in the delivery sector, you're in the construction sector, you need to choose individuals that fit for purpose for your own business. And this is, I think, one of the criteria that when you are demonstrating those nominees to the regulator, that look at from a perspective of, is this person convenient for that particular company.
Thank you for that. Actually, I have a question, maybe in the minds of many of the business owners. So the idea of governance involves letting go or losing control. And at the end of the day, as a business owner or founder, they know what's better for their company when it comes to decision making. So what can you say to that statement?
To be honest with you, I think it goes back to the principles. A business should be someone who's investing his money in the business should make sure that he's probably putting his business in the hands of the best qualified people. The element of trust should be the main element to allow that management to also execute its mandate, right, in the best interest of the company, which ultimately returns with a benefit to the founders and the people behind those companies. The founders will never lose control eventually. He has the right of supervision, questioning, and approving at the end of the day, evaluating the performance of the management. Also, excessive control and excessive pressure on the management will not allow the management to execute its mandate and independency. The founders have obviously an important role. They obviously approve in the end of the year the performance of the management. They approve whether they are entitled to remuneration or not entitled to remuneration. They have periodic, all-time access to information. There is never restriction to information. They can visit the company every single day, look into what's happening in it, and question. But I think it's also partly to allow this management to execute its mandate without interference. And this is regularly, it's something common. I establish a business, I consider I know the best interest of it. But then I should ask a question for myself, then should I be the manager, the shareholder, and do all functions? I cannot do all this because that's the main reason why I invest in qualified people, and to allow those qualified people to come in and demonstrate their quality, I should allow them space. And the governments and structure and policies that are made to allow this space to happen, and then to allow questioning that managerial, to question I would say the performance at the end of the year.
And I think just to add to that is that, as we mentioned, the board members are there to act in the best interest of the shareholders. So at the end of the day, the mandate lies with the board to act in the best interest. And Obviously, listing a company has got its benefits from a financial perspective, but with it also comes the responsibility and the clues in the word public. Information has to be disclosed, things need to be made available, and this is the nature of what happens when a company goes public, and it needs to adhere to the safeguards and the regulations that govern that arrangement.
Just to add quickly, Sulaiman, I'm conscious of time,
Yes.
is that governance applies to all companies. Companies that are limited liability companies that are public shareholding company are heavily, and I think there is an urgent, I think, need for them to think of these issues. It doesn't matter if you're going to list or not. The governance is an important function in the company, and I believe many companies should start look at it for the purpose of succession planning as well. It's very important to make sure that the company continues with the president, with all the founders. I think that there is a lot of work to be done on the governance side when it comes to companies that are thinking of listing or making or going for an IPO. I believe engaging with consultants, not only lawyers, but engaging with consultants as well, because that motivates the business to look into how shaping up the company, seeing where the loopholes are, and enhancing the value. All these criteria affect the value of the business in the end of the day. And when you are going public, you will be concerned of how much I'm going to return, how much I'm going to make return of doing an IPO or listing. And governance and the structure of the company plays a main role in determining the value.
Exactly. So it's like an insurance policy for the owners, and the benefits have to outweigh the negatives. Thank you so much, Elias. Thank you so much, Maha. It's for your time. It was very insightful. I don't think we have any more questions. We wrap up this first session. Just to remind everyone, a recording of today's session will be available and will be sent out shortly. We look forward to seeing you again in the next session on the legal and compliance scheduled on 20th of April, inshallah. Thank you and have a good day.
Thank you.
Shukran. Assalamu alaikum.